Hello. The Divine Code reading for April 17th, pages 629 and 630. We are in the chapter Laws of Saving Oneself or One's Property at the Expense of Another's Money and Taking the Law into One's Own Hands. Topic of number 8. Although, as explained, in general, one is not allowed to take the law into one's own hands. This applies only if the restitution is taken in a way of stealing, such as seizing an item in restitution for an unpaid loan or a different stolen item. So if the person is taking an object that is not the same as the object that was stolen. A person stole one object and the owner of that object wants to get his item back, so therefore he takes another item that he says, okay, now I have this item, so we're even. We're not allowed to do that. Or if the person took money and he's, if the thief steals money and the victim of the theft were to say he's going to take a equal, he's going to take, if the thief stole $100 and the victim says, okay, he's going to take $100 worth of items from the thief, that's not permitted because it's not his. If it's his item, then he can take it. But if it's not his item, then he's not supposed to take it. It doesn't belong to him. Therefore, he doesn't have the right to take it. Even if the thief took his item, it doesn't. The two don't equal each other out. It has to be the same item. However, it is permitted to seize an item in collateral as collateral until the matter is settled in court, and this is not considered theft. So the victim lost a $100 item. He goes and he takes a different $100 item that he has access to. He can't get the original item. It's in a safe. So he takes a $100 item that is equal, that's easily accessible, that he's going to hold on to that until it gets to court. We're being told that that's permitted. And this is not considered theft. So it would not be considered theft for him to take the item as collateral. This applies whether it was taken as collateral for payment on a purchase or for late payment for a service provided or for the return of a stolen item or for replacement of a loan. And we see Shulchan Aruch Koshan Mishpat 37:14 and Shakver 37:6. Shulchan Aruch Harav, Laws of Loans, topic 14, and the Laws of Robbery, topic 29. Although it was explained there that it is forbidden to seize collateral for the loan, this applies to a Jew for whom there is a Torah prohibition to enter the house of a debtor to demand collateral. This is not prohibited to Gentiles. So in the Jewish system, and this is because they're in Gullus and they're not able to collect. The courts do not have the authority today to collect payments from they don't have the official authority. They can suggest it strongly, but they don't have the legal authority. A Jewish court today does not have the legal authority to seize a payment, to force a payment from one person to another. And therefore, what the rabbis have created within the Jewish law, the ability to do it on one's own. Now, there's still, how that actually works. It needs to be in conjunction with the courts, but the authority goes on to the individual rather than on the court, because the court doesn't have the ability to have authority. Although it might be the court, the individual might ask the court to be their agent, which is allowed. But the authority is coming from the individual, not from the court in today's society. When there's a temple and when the court system's operating properly, it would be different. But what we're dealing with is right now. Therefore, within the Jewish law is the ability to seize the property, because that's how it's done. That's how it's necessary. What happens, the divine code has taken that rule and applied it to all Gentiles. I'm not sure. In fact, I'm pretty convinced that that doesn't make sense for Gentiles. But that's kind of the premise for this chapter. Then within the Jewish system, they say, well, there's for the purpose of collateral, if it's not the person's object that's being seized back. If it's the person's object being seized back, then the person can go into the Jew can go into the other Jew's house to get his item back that belongs to him. And then if it goes to court, then the court will decide who it actually belongs to. But if the person is convinced it belongs to him, he can go into the house. The Jew can go into the other Jew's house to get the item. But he cannot go into the other Jew's house to get collateral, because that's there's a biblical prohibition against that. So what they're saying here is that biblical prohibition does not extend to non-Jews. Therefore, the non-Jew would be allowed to go into the other person's house to get collateral, to seize collateral. And I would suggest that they're not allowed. The non-Jew would not be allowed to go and seize the item himself, because we have a functioning court system that has the police department and the agents of the court to do that for them. Therefore, there's no logical reason for the non-Jew to have this chapter, this section of taking the law into his own hands, because we have a law. We have to work with the law. So I'm giving what it says in the divine code. I just wanted to state that I don't agree with it. Some rabbis will get upset that I have the audacity to say I don't agree, but the fact is I don't agree. Topic number 9. It appears that even if the thief stole the stolen item, if the victim never despaired of recovering it, in which case the law is it must be returned intact. The original owner can take the law into his own hands and forcibly take the item from the buyer, even though the sale was done without the buyer being aware that the item was stolen. Oh, if the thief sold the stolen item. Okay, so now, according to this, if the thief, we learned earlier that if the thief sold the item before the owner despaired, that invalidates the sale, and the item still belongs to the original owner, because the original owner still expected to get it back. So after the sale, the item would still be required to be returned to the original owner. Even if the person unwittingly bought it, he thinks he bought it correctly, it doesn't belong to him, it still belongs to the original owner. The original owner can demand it back. And here it's stating that the original owner can walk into the person's house and take it back forcibly. This is implied for Mima Koshen Mishpat, chapter 4, in the name of Ritva, or he found it. Just quote, or he found it, a deposited item, in the hands of another, end quote. And there is no logical difference between seizing a deposit or one stolen item. So it's understood that if a person if the person deposited something, he has someone as a guardian for something, and the guardian somehow the item wound up in a different person's hands, the owner of the item can go and take it back from the other person. And the laws of retrieval of stolen property is almost fused with the laws of a guardian. The thief is a type of guardian, and the item is like an item that is guarded. Therefore, we can learn many of the laws from the law of the guardian. Topic number 10. If the worker steals fruits from a field he is working in, the owner may deduct the value of the fruits from the worker's salary. So the worker is working out in the field. He's working at a factory. He takes some things for himself that he's not supposed to take. Now, there's certain rules about the worker being allowed to eat while he's working in a field, when he's picking produce. It's very complicated. These laws may or may not, it's hard to tell, may or may not apply to the non-Jewish workplace. It's something that exists within the Jewish workplace, but it's unclear about if the laws apply in the non-Jewish setting. However, if he's not following the rules and he's taking things, he's taking it for the sake of taking it home, which would, in either case, would not be allowed. If the employer catches this, if the employer knows that this is happening, he can very easily just deduct it from the worker's salary, the worker's pay. And that would be probably the easier way of handling it. Instead of getting the police involved, he would be permitted to do that. However, if a sharecropper steals from the fruits, he must share it with the landowner. So this is a partnership, business partnership. One person owns the business, the other person does the work, and they split the profits. Or or it could be that both of them have money in there, but they're business partners. This would be a case where someone's embezzling from the company, even if he's a partner within the company. But when he embezzles it, he's taking it off. He's skimming it off the top. He gets its pure profit, as opposed to letting it go through the accounting system, where he only gets a percentage of the profit. He only gets a percentage of the till. In the case of a sharecropper, perhaps they are supposed to split it 50-50. The owner of the field gets half of the produce, the sharecropper gets the other half. Well, if the sharecropper takes a portion of it up front, and then that reduces the amount that they split, so the thief would get a larger amount and the victim gets a lesser amount. So what happens in this situation? It is forbidden for the landlord to deduct from the sharecropper's portion of the fields, just as it is forbidden to steal from a thief. The sharecropper took the fruits not as his contracted portion, but as a thief, which is explained above in topic 7. One may not steal something else in comparison to something that is his that was stolen. And it's tractate, and we learn that from Tractate Baruch 5b, Mordecai Baba Kama 330, and Shokanor Korav, Laws of Robbery, topic 27. So we're learning that he can't seize it back. Now there's two questions here. One is, was it taken before or after it was split? You have the fruit in the field. And then the fruit is gathered together, and because you don't know how much fruit is in the field until it's gathered together. When it's gathered together, they take it, they split it in half. They bring it to the collection location, and then the sharecropper and the owner, the business partners at this point, split it in half. Each takes his half. So was the taking of the theft before or after it was split in half? Did the sharecropper maybe every 5th bushel of apples that he picks, he takes 1 bushel of apple back to his farm, back to his barn, and he's got a secret room that he puts all the extra apples. So a portion of them go back ahead of time, or is it when it gets together within the the one lump sum in the collection area, or is it after it's split, he comes back and swipes some apples from the owner's pile? At what point is this happening? Is it, and the other question will be, is the item considered like a commodity? If it's like a commodity, then it's similar to cash, in which case it doesn't matter if it's one specific bushel or if it's just the concept of a bushel that's taken. And I don't see much in here where, so far, I haven't noticed anything that discusses the concept of commodity, and I don't know if that concept exists within Jewish Torah law, within what the rabbis have dealt with. But today we have this concept of commodity. It's a product of the modern marketplace, and would that make a difference? If it's considered a commodity, that's where we don't care about a specific bushel of apples. We care about the concept of a bushel of apples. So if he takes a bushel of apples, is it like money where you can take another bushel of apples and it's considered the same thing? Or is it just considered a specific bushel of apples that you can't just take a different bushel of apples and consider it the same thing? That's something that needs to be looked into more deeply here for this question. But we're dealing with the issue of an embezzlement within a company, which affects the entire bookkeeping of the company. We could think of it as like if a business, there's a business partners, and they split their profit at the end of the day, and their cost is $60. The cost of running the business is $60 during the day. If they get $100 in the till, they get $100 receipts for the day. That would give them a profit of $40, and they would split it $20 and $20. However, if one of the partners were to take a $20 bill before it's counted, put it in his pocket, now they have $80 in the cash register with a $60 cost for the day, and they were to then have a $20 profit, which would be split $10 and $10. So in that case, the crooked partner would go home with $30, and the victim partner would go home with $10. That seems to be similar to what's being said here. So would if the victim partner were to notice that the other person put $20 in his pocket, could he then take the entire $20 and say, okay, now we're even because you have $20 in your pocket, and he's got the one person's got $20 in his pocket, the other person's taking home $20, so they're even. Can he do it? Can he do that? Now with cash, we know it wouldn't be allowed. He would be allowed to do that with cash. And the question is, how do we deal with a sharecropper's product? Does that work the same way, or does it work as specific product, where it would have to be the specific product that was embezzled, with the stuff that's hidden away in a secret room in the barn? Would it have to be that specific items that would have to be corrected, or can it just simply be, they make good with what's on the floor, what's openly available? That seems to be the question they're asking here. Nevertheless, this is not considered completely as theft, and the owner went back. If the owner went and took a comparable amount of fruits from the sharecropper in restitution, he is not judged in a court as a thief, and that which he has seized may not be taken from him. And it's responsive Rosh Principle 64, Part 1, C above 1.5. So so this is a curious thing. The victim of the theft would be allowed to take his portion from the the crooked partner's product, the product from the sharecropper. And so in that case, it's being treated like a commodity. He's treating it like a commodity. According to this, he's not allowed to do it. But if he does do it, he is permitted. He is not treated as a thief. He's permitted to keep the extra amount. So he's not allowed to do it, but he's permitted to keep it afterwards, which is it's a curious in-between zone that is created basically because it's a commodity rather than a total object. It's an in-between zone between money and an object, and that's how the rabbis have worked it out as to how to handle it. So he's technically not permitted to, but if he does, it's okay. He's not and he's allowed to keep the product. So it's hopefully a court would make more clearer policy in this regard. You wouldn't create these in-between zones. It's a Torahism to create these in-between zones, but a functioning court should give clear policy in this area. Topic number 11. The above is said regarding seizing the belongings or money of a person who stole or who owes payment. A Gentile may, however, hold onto an item that was entrusted in his care by a person who stole from him, or who was overdue in payment of a debt, in order to collect the person's overdue payment, even though there is no surety that it may be the legally correct for him to keep the entrusted item. And that's see Sefer Mirat Eliam, Kosha Mishpat 4:3, and Uraterm 4:2. So the person, okay, so the thief or the person who owes money entrusted an item to the victim, and so the victim can just simply hold on to the item. He didn't take the item from the thief or from the person who owed the money. It was just handed to him, and apparently wasn't handed to him necessarily as a collateral, but somehow it was just entrusted to him as a separate issue altogether. The person he's allowed to hold on to the item and say, I'm holding on to the item until the person pays him back, or until the thief makes restitution or brings the object back. He's allowed to hold on to that. So in other words, he takes something that was entrusted to him, that he's the guardian for, and he uses that as collateral. And he does not need to return it until his judgment is handed down in court. So in this case, and this may be where a lot of this idea of taking an object in, eventually it has to be handled through the court. Otherwise, we have anarchy. The courts have to be involved in this process. People cannot just simply be taking back items, because if we allow that, it needs the declaration by the court, and that's part of the Noahide requirement to have courts of law. We have to rely upon the courts in this area, in these areas. We can't just take things on our own. Topic number 12. Anyone who mistakenly seizes another's item, think it was either his rightfully should belong to him as a legal judgment, is not considered a thief, even if the court determines the item was not rightfully his. Now, this is the dilemma: is a person he might know that the thing was stolen from him. He knows that that's his object. He's sure it's his object. Unfortunately, he doesn't have the legal paperwork. He doesn't have legal proof. He doesn't have anything to back up the fact that it's his object. but he knows it's his object. The thief smirked at him when they passed on the street. He knows it's his object, but he can't prove it in court. So if he goes and takes the object that he knows belongs to him, and the thief smirks some more, and he takes him to court. He takes the person to court, and the court finds in favor of the person who had the object and takes it away from the person who's sure it belongs to him and gives it back to the person who was holding it. The person that was sure it was his is not held liable because he went to the court about it. He's not doing stuff. He went to court, but he has to give it back. Likewise, if one was harmed or injured in a way that would usually bring about a monetary award in court from the damager, and although the victim is forbidden to seize the money, until the court makes a judgment, the victim is not judged as a thief if he seizes the money. So in this case, the person, he got hit by a car, and he realizes he's got damages because he's injured, and he takes items from the person that damaged him, with an understanding that those damages rightfully belong to him. It goes to court, and the court rules against him, and says no, it doesn't belong. He doesn't have the damages. He was jaywalking, and he doesn't have a right to those damages. So the court rules against him. Then he's not considered a thief for taking the stuff, but he would still have to give it back. See Shokunor Karav, Laws of Robbery, Topic 1, in the parentheses, quote, "This is a type of pain that does not lead to obligation for restitution," end quote. That is, if the pain inflicted can obligate the perpetrator for restitution, and the victim sees the money from the perpetrator, the victim is not considered a thief. It is obvious that the victim has no permission to do so at the onset, and no person can take the law into his own hands unless it is clear that he is taking something that already belongs to him. So in this case, until the court, it's not the case earlier where the object belongs to him and he's taking it. At this point, the court is the one that determines damages. We're talking about pain damages. We're not, we're talking about something that has to be determined by the court, that this belongs to the victim of the injury before it actually belongs to the victim of the injury. The court makes that determination. The person can't just take it and say, well, I'm in pain, therefore I'm going to take his belongings, because it doesn't belong to him. It doesn't belong to the victim. It doesn't belong to the injured person yet. Since the restitution for damage can only be addressed by the court, any seizure or restitution it is obvious that the victim has no permission to do so at the onset, as no person may take the law into his own hands unless it is clear that he's taken something that already belongs to him. Since the restitution for damage can only be assessed by a court, any seizure of restitution before the court renders judgment is prohibited. Nevertheless, since the perpetrator has a monetary obligation to the victim is not liable for theft if he seizes it before the court renders judgment. Renders judgment is prohibited. Not sure how that's. Okay, so the person is not permitted to take the restitution ahead of time before the court makes the judgment. It's not permitted to do that. Nevertheless, since the perpetrator has the monetary obligation to the victim is not liable for theft if he seizes it. So the assumption is the victim is going to receive a judgment from the court in his favor. The person that's in pain, the injured person, the assumption is he's going to receive compensation through the court system, and therefore he's not permitted to take the item. But if he does take it, he is not held as a thief for kind of jumping the gun and taking it ahead of time. But after the court determines that the defendant has no monetary obligation to the plaintiff, the plaintiff is considered a thief if he still goes ahead and seizes the money. If the plaintiff has seized the money already and the court determines that he is obligated to return it with any hesitation on his part, transgresses the prohibition against withholding the payment, and as was mentioned above at the beginning of this unit. So the person who takes he assumes he's going to get compensation through the court system. He jumps the gun. He takes it from the person that injured him. If the court, he's not considered a thief for doing that. However, once the court renders its judgment, if the court renders its judgment against him, and if he goes ahead afterwards and takes the item after the court says he doesn't get the restitution, but if he decides on his own he's going to take it anyway, that's considered theft. And if he took it ahead of time, and if the court determines he doesn't get what he took, he has to return it immediately. And if he holds on to it, that holding on to it is considered a continuation of the theft, and he would be considered a thief at that point. So ultimately, everything that he is doing, and I would suggest anything that we're talking about here about seizing items, even if the object belongs to him, he thinks it belongs to him, the court needs to be part of the process. And it might make sense to have the court hold on to the object rather than the person who thinks it belongs to him hold on to the object, but rather the court should hold on to the object until the determination is made. Thank you.